Note, defendant Laird stated that defendant John Doe was the supervisor. Okay, here we go. We're trying to get to some more juicy parts here. They're starting to get a little dry. You can pause this if you want it and read some of this. Da, 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 da. A lot of case law being kind of argued back and forth here. Okay, here we go. This is where I kind of jump back and forth a little bit. Not so much rambling, but it's out of context. It just skips around. As to the threats to law enforcement, plaintiff presents the following. According to the Bureau of Labor Statistics, fatal occupational injuries amongst law enforcement officers, which includes homicides, dropped 24% from 2018 to 2020 from 127 to 97. That's because some of the case law that they cited had the stupid, idiotic in this day and age embedded in there. When police officer jobs have actually gotten less dangerous, not more so. Truck drivers have a higher death rate than police officers. Plaintiff alleges that the PD officer's detention of him and request for his ID violated his Fourth Amendment right to be free from. Okay, this is good. Let's go ahead and go into this. If the officer he just talks about reasonable suspicion. So I go, defense misses the entire point of the plaintiff's complaint. Either has not read the complaint, or has not understood the complaint, or has confused the facts from another case with this one. I genuinely believe that because they're just so off base with this. Plaintiff is very knowledgeable on the principles of Terry v. Ohio and how they apply. Plaintiff is not filing suit against the police department and its officers for applying the principles of Terry v. Ohio. Plaintiff's Fourth Amendment rights were violated when he was arrested after simply asking for the defendant officer's name and badge number. There is no legal precedent, no state or federal law, no case law, and no application of the totality of the circumstances doctrine which justifies an arrest when a person with whom an officer is speaking asks for the officer's name and badge number. The officer was now. This is conclusory, okay, but I'm going to allow it. The officer was angry at the plaintiff for the plaintiff's free speech, made a feeble attempt at establishing reasonable suspicion by falsely claiming that the plaintiff was trespassing, and upon being asked for his name and badge number, immediately arrested the plaintiff. We have already thoroughly established, and the video evidence proves, that plaintiff was not in fact trespassing, was not and had not committed a crime, was not told he could be arrested, was not told to leave, and was not asked for ID, and when asked what he was doing, was not, under the Fourth and Fifth Amendments to the U.S. Constitution, legally obligated to answer the officer's questions. Fourth and Fifth Amendments. Therefore, the Terry v. Ohio decision defense points to is null and void, and fails on its face to establish legal justification for a detainment, and fails even more to justify an arrest. Plaintiff specifically alleges that he was arrested by the defendant officer. The plaintiff's unlawful arrest is not swept away by the fact that a detective ordered the officer to release him. Defense attempts to cleverly use the fact that the plaintiff was ordered released to claim that the arrest was actually just a investigatory stop, because they know that the standard for such a plea is much lower, and the officer can escape all but the most intense scrutiny and always fall back on the exemptions granted to officers who use their personal judgment and perceptions, which are highly subjective. They were trying to get away by saying it was just an investigatory stop. That's ridiculous. Even if they were to somehow, by some strange Christmas miracle, prove that it was, what was the basis for investigating? What were they investigating? A man with a camera? It still fails on its face, but that's not what happened. I was arrested. Therefore, they need probable cause, which they can't even come anywhere near proving. Man with a camera. However, plaintiff has proven that the officer made an arrest as per the defendant officer's own admission and statement to the plaintiff that you're about to be arrested for failure to ID. This statement by the officer would lead a reasonable person to believe, and that's the standard that the Supreme Court uses for an arrest. If the person of a reasonable person believes that their movement has been restricted, they're no longer free to leave, they're under arrest. That's an oversimplification. But basically, you're about to be arrested for failure to ID. The statement by the officer would lead a reasonable person to believe that they were under arrest and being charged with a crime. Defendant made his intent known to charge a plaintiff with failure to ID and attempted to use this charge as leverage to coerce the plaintiff into surrendering his Fifth Amendment rights. And then I explain what the Supreme Court has identified as 3 tiers of police contact and how you need probable cause for an arrest. Okay, this is good. I'll read this. Contrary to allegations by the defense, the plaintiff did not want to be unlawfully arrested. Plaintiff's goal is to educate the public and encourage training by police departments on the legality of the First Amendment, not to file lawsuits. Plaintiff attempted to dialogue with the officer and to educate him on the legality of First Amendment activities conducted by the public on property that they, the taxpayers, fund. But before the conversation could continue down this road, Defendant Laird aggressively arrested the plaintiff. This is what the plaintiff alleges in his complaint. Plaintiff understands a consensual stop versus a detention, reasonable suspicion versus probable cause, and whether or not the totality of the circumstances warranted a detention. The plaintiff is a two-time graduate of the Federal Law Enforcement Training Center in Glencoe, Georgia, and worked for 11 years as a federal agent with the United States Department of Homeland Security. Plaintiff is well versed on matters of law enforcement and the legal principles involved in being detained and questioned. Plaintiff received extensive training on these matters, both during training and while working as an agent. While conducting First Amendment activities and public photography, plaintiff is frequently contacted by law enforcement and asked to present ID. Trespassing is one of the most common incorrect allegations made by police officers who want the plaintiff to leave a building or property that the officers have been summoned to by the employees of said building. Up until this incident, however, plaintiff has always been able to dialogue with and educate the officers and the employees regarding his lawful reasons for being present, and except for one prior incident where officers unlawfully told him he was trespassed and allowed the plaintiff to depart the property, at which time the plaintiff departed the property under protest and filed complaints against both officers and their supervisor, has always been able to continue his First Amendment activities. Plaintiff has never, prior to this incident at South Padre Island, been arrested for his photography or for any other reason in his 45 years. Let's see. Okay, this part's interesting. They tried to use this story to defeat my argument, and all they did was help me prove my case. Defense continues. Emphasize portions added by plaintiff. This is the defense. Notably, courts in very similar circumstances to what plaintiff factually pleads, and I interjected, similar in that they also failed to prove that the actor was in violation of a law when contacted, have found reasonable suspicion that criminal activity was afoot for purposes of a detention. Videotaping of routine activities in front of a police station potentially threatened security procedures at a location where order was paramount, and an objectively reasonable officer could have suspected that the detained individual was casing the station for an attack, stalking an officer, or otherwise preparing for criminal activity, and thus filming of the routine activities of the station were sufficiently suspicious to warrant questioning and a brief detention. Under a totality of the circumstances, facts are sufficient to create a reasonable suspicion that criminal activity is afoot when the facts consist of an individual wearing a backpack containing unidentified items, videotaping the parking lot of the Addison Police Department without having without having requested permission to do so, informed the police department of his reasons for doing so, or even notified the police department that he would be doing so. And when approached by officers, oh my God, refused to tell them why he was videotaping the police department and refused to identify himself or provide officers with identification. And they think that this strengthens their case by saying this. Virtually the same factually pled scenario exists here. And I had to interject again. That's me in bold. In other words, pre-crime or prior restraint. The plaintiff, in that case, was working on a story about the police. Prior restraint is specifically about journalism. Defense states, virtually the same factually pled scenario exists here. I agree with this statement 100% with no objections or reservations, and my reason for doing so is that the virtually same factually pled scenario demonstrated that not one action by the plaintiff listed in the example was a violation of the law or constituted a lawful basis for the arrest. Defense repeats on more than one occasion how plaintiff wouldn't tell the officers why he was there, as if this is somehow incriminatory and proves the plaintiff's guilt. Defense seems to be confused between courtesy and law. There is no law which states that a person must notify a police department prior to recording it from a public space. The defense seems to believe that citizens must request permission from their government before exercising their rights. A citizen with a camera and a lawfully carried and displayed firearm does not have any legal obligation to give advance notice to a police department of their intent to record from public. Further, when approached by officers, it is well established by the Fifth Amendment and existing case law that a person does not have an obligation to speak to police officers or to answer any of their questions, and especially not to provide ID. These facts are glaringly obvious to anyone with even a cursory understanding of the Fourth and Fifth Amendments to the United States Constitution. The defense has assisted the plaintiff greatly by using this example and by stating that it constitutes virtually the same factually pled scenario by the plaintiff. Based on their own pleading, I was not in violation of any laws, had no legal obligation to notify the police station of my intent, and had no obligation to answer any of the officer's questions or to present ID. Despite these facts, so eloquently established by the defense, thank you very much, I was still unlawfully arrested, detained, placed in mechanical restraints, searched, confined to the front of a patrol car, had my property seized and thrown to the ground, and was threatened with jail time for not surrendering my Fifth Amendment right against self-incrimination and for not providing ID. See Brown versus Texas and Texas Penal Code 3802. The facts of the above case do mirror those of my complaint, except that I was not carrying a firearm or a backpack. Despite neither one of those actions being illegal, their absence from my case further proves the lack of reasonableness for my arrest. Perhaps the defense believes that because the quoted case was dismissed, that somehow the actions of the obviously overly aggressive police officer were justified. It is apparent upon reading the case that the officer had his ego bruised by being ignored by someone whom the officer believed should have immediately surrendered all of their constitutional rights and satisfied the mere suspicion of the officer masquerading as reasonable suspicion and concern for public safety and answer all of his questions, to include submitting to a thorough background search and check for active warrants. Despite the above case being ultimately dismissed, the Supreme Court in Brown versus Texas disagrees with the defense, and the fact is that said plaintiff's constitutional rights were still violated and he was still body slammed and injured. If you guys want to read that case, it's kind of interesting. If the officer was so concerned, he would have shot and killed the plaintiff for displaying or manipulating the firearm in a manner that presented an immediate threat, or would have simply arrested him based on probable cause that he was planning an attack, and not just exercising the rights of a free American citizen in public, whose activities were not just legal and lawful, but protected by the U.S. Constitution. And needless to say, but I will, the Second Amendment allows citizens to carry firearms. And this is where I just have to lecture them. Living in a free and open society is dangerous and comes with inherent risks. Police do not always get to know everything a person is doing and are bound by the Constitution not to interfere with the rights of those who may indeed have criminal intent until after that intent is made known. Now, a lot of people would disagree with that, okay? But I'm sorry, it's the truth. Until after that intent is made known, is manifested in some way, or the officer has reasonable, articulable suspicion to investigate further. It is one of the dangers that comes with being a police officer. It is not incumbent upon free members of society to accommodate the overreaching and unlawful intrusion of law enforcement against them, simply because said intrusion may prevent criminal acts. Public photography and First Amendment auditing is increasing in this country, not decreasing, and many, if not most, police departments, since as far back as 2002, are providing additional training to police officers, reminding them that public photography alone is not reasonable grounds to stop and ID someone or to make an arrest. And then I go on to show that the Chicago Police Department had a policy preventing officers from even interfering with photographers. I go into the U.S. Department of Homeland Security memorandum, the 2018 memorandum about photography in government buildings, and I go into the TSA's policy that says TSA does not prohibit photographing, videotaping, or filming at security checkpoints. Okay, and so my big underlying portion here is that plaintiff alleges that if a similar policy had been in place at the South Padre Island Police Department at the time of his arrest, this incident would never have occurred. Now, how much more evidence do you need that these officers were not properly trained? And that falls upon the chief of police in the city. The above solidly encases the plaintiff's cause for which relief should be granted. Further, now, I should have put this in a different part of here, but whatever, I added it here. Why was I released from custody if I did not provide ID or tell the officer I was there? Why did the detective order me released? If trespassing occurred, as claimed by the defense, why was the arrest abandoned? The difference between Defendant Laird's statement and his report of how he observed me recording the officers and that's the way he said it, their vehicles, I had to put in parentheses, our vehicles, and how he detained me for said activity is in stark contrast to the direction given by agents in the Homeland Security Bulletin, which described the same activities and cites case law, court interpretations, and the First Amendment as to why these activities are permitted. These directives issued by the governing bodies of the respective agencies, when compared to the actions of Defendant Laird, whose department had no such directive, is the death knell to the defense's motion. The direct causal link between the lack of training and the officer's unlawful actions are clearly established here. They are. That's all there is to it. Okay, and then I go into Brown versus Texas, and I cite the entire statute. And at the bottom, I quote from Brown versus Texas: "The balance between the public interest in crime prevention and appellant's right to personal security and privacy tilts in favor of freedom from public interference, police interference. This statement by the Supreme Court is the standard on which this case should be decided." And then I did a little more lecturing here. "Our rights do not exist to sit on the pages of law books. If we do not exercise them, they will go away." The plaintiff asks, on October 14, 2020, what made the passage through an open, publicly accessible breezeway behind the publicly funded police department with all non-public entries secured by keypad doors such an exigent situation that it required his immediate arrest for exercising his First Amendment right to record a city building, when major metropolitan police departments, federal buildings, and international airports allow such activity, and the officers there are instructed not to interfere with, investigate, harass, or discriminate against them, or to make arrests for such actions. And what part of a citizen exercising their right to free speech was just cause for Defendant Laird to arrest and detain me when the Supreme Court says that specific facts alluding to a crime are necessary for such actions? A final point about the gray areas allegation by the defense. There are no gray areas when it comes to civil rights and civil liberties. We have them or we do not. Brave men and women have and continue to risk their lives, and many have and continue to lose their lives to protect our freedoms. And for the defense to reduce the rights of a citizen of these United States to what he perceives as a game or an attempt at agitating police officers is distasteful, to say the least. If you are a police officer and you are easily agitated, you should not be a police officer. You are supposed to keep your emotions under control. Plaintiff is eager to move forward with this case so that upon discovery, the identity and actions of the other defendant, I just want to identify the other defendant. So I stole that death knell claim from him. He said that the death knell to my case was that another auditor conducted the same activities as me and was not arrested. But he missed the entire point of that as well. Rather than contradicting the allegations made in my complaint, this was originally the basis for my 14th Amendment violation, as the person in question is white and I am black. I was alleging that I was treated differently based on the color of my skin by white and Hispanic officers who, upon observing a white First Amendment auditor engage in the same activity, did not detain, confront, handcuff, physically accost them, or seize their property. I chose not to include this as part of my complaint. Please get that, trolls. I chose not to include this as part of my complaint due to the political climate at the original time of the incident, and because it requires extraordinary evidence to prove racial discrimination, guys. But since the defense has insisted on bringing this up in an attempt at pointing out a deficiency in the complaint, I have been forced to include it now as part of the record. That's all I did. Later on in his response, he said, the plaintiff suddenly began talking about racial discrimination, but he didn't provide any facts to back it up. No, I did not. All I did was point out how stupid it was for you to bring it up when I didn't, and how that forced me to have to talk about it. But I'm not including it in my complaint, unless I have to. But since the defense has insisted on bringing this up in an attempt at pointing out a deficiency in the complaint, I have been forced to include it now as part of the record. Whereas, although alluded to in the complaint against the officer, not the lawsuit, the actual complaint, submitted to Internal Affairs, was omitted in my complaint before the court, my lawsuit. I have included with this response a list of comments posted on the South Padre Island Police Department's Facebook page by members of the public who saw the video of the arrest and went to the department's Facebook page to voice their disgust and call for the arrest and prosecution of the officer involved. This list is but a smattering of the massive number of comments regarding this incident posted on the Facebook page. I'm going to read some of those comments. But check this part out. He tried to accuse me of doing this so that I can file lawsuits. First, I talk about how this incident has chilled me and basically shut down my channel and stopped me from doing First Amendment auditing, okay? This has been an immense physical, mental, and financial burden for me, and because of it, I have all but abandoned my previous activities as a First Amendment activist. Despite the defamatory allegations by the defense as to my intentions for recording police officers, I have 4 previously recorded, publicly viewable videos on my YouTube channel, one showing a violation by police officers, one by a military police officer, another by county contracted security guards, and finally, another by a Seattle Port Authority contract employee, all of which could have and should have resulted in a civil lawsuit, but I chose not to follow through. This was because I measured the consequence of filing a lawsuit, which could serve as a deterrent to future violations, with the loss of my privacy and anonymity. In this incident, however, the violation against me was so severe that I had no choice, despite not being able to hire an attorney, to take action and seek relief. I just talked about how that my First Amendment has been chilled due to this incident. And that's it, guys. That's basically the end of it. Yep, that's it.